This presentation covers the second half of Chapter 4, which is the administration chapter in the Therapeutic Modalities book. So one thing to consider is that the Food and Drug Administration, also known as the FDA, has a Center for Devices and Radiologic Health, and it regulates a wide range of therapeutic devices to ensure patient safety, to evaluate claims regarding their efficacy, so whether or not they actually work, and to eliminate unnecessary exposure to radiation emitted from the device. So some of your modalities, such as e-stim or ultrasound, are going to have a rating on them of Class 1, Class 2, and Class 3. So Class 1 are considered very safe, low levels of radiation, not a whole lot to worry about, where Class 3 are going to be the perhaps higher levels of radiation and maybe not quite as safe. They still are going to have, all of those will have a certain base level of efficacy. In other words, the FDA will have to assure that they actually do something therapeutic for the patient. In obtaining approval, the device will have to have been shown effective. So the deal for the athletic trainer then is to realize that if something is rated by the FDA as a Class 3, then you're going to have a physician to sign on to supervise the use of that modality perhaps. So keeping in mind that there are FDA classifications of modalities will be helpful as you move into selecting your own modalities and how to manage them and the administrative aspect of handling modalities. The FDA, of course, is also a major regulator of over-the-counter and prescription medications, so this isn't the first time that you've heard about them. All right, another administrative consideration is the OSHA regulations. So the Occupational Safety and Health Administration develops codes that are safety standards and regulations to prevent work-related injuries and illnesses. And through an enforcement branch, they also hand out fines and prosecute employers who do not comply with standards. So the biggest one that athletic trainers, of course, have to deal with is universal precautions, and that would be the set of standards that help prevent against accidental contact with biohazards. So each institution must develop an exposure control plan to protect its employees from exposure to bloodborne pathogens, also known as biohazards. This means that sort of intermingled with your modality use, you need to make sure that you have your bloodborne pathogen policies and procedures, also known as your exposure control plan, in place to handle any issues related to that. All right, next up, let's talk about the medical documentation. That's a pretty big issue of the administrative side of athletic training. So failure to maintain accurate, legible medical records may result in a claim of professional negligence, and the absence of these records places the caregiver in an indefensible position. It's kind of a saying in athletic training then, if it wasn't documented, it wasn't done. So if you want to be able to prove that you provided the best care for the patient's ACL tear, AC separation, ankle sprain, mono, then you need to make sure that you keep good records of it. Each state's statute of limitations determines the length of time that medical records should be kept after the patient is no longer receiving care. So you kind of have to park that away in your mind of, when you keep records of, say, your men's soccer team, what are you going to do with the graduates' medical records? So once the students graduate, do you have to keep those records for 5 years, for 10 years, indefinitely, 20 years? And what you would do is you would consult the legal counsel, the lawyers, for the institution or the setting that you're working in to find out what they consider to be best practice. And they're going to base their answer, by the way, on whatever the state statute of limitations is. And also, the statute of limitations is a concept that means you can be sued for things that happened in the past, but only up until a certain point. So if the law in Virginia was that you could only sue for medical malpractice up to 10 years, then after a 10-year period has expired, a patient could no longer sue you. That means you would no longer have use of those records or have need for those records. So that would tell you that you need to keep your patient records for 10 years, and after that, they could be destroyed. All right, so documentation helps to prove continuity of care. So when you document examination findings and the intervention plan as specifically and clearly as possible, the continuity of care can be maintained by more than one clinician so that you can run your clinic more efficiently. So I think that continuity of care is very important in the Longwood athletic training room because multiple athletic trainers can treat a particular patient. They have a good amount of overlap in that athletic training room. The medical record should include all communication to and from other healthcare providers, from the patient, to and from the patient rather, to and from the family members. This way, every care provider who might be taking care of a particular patient would understand what's going on and be able to sort of maintain progress with the intervention plan so that the patient continues to get better. Treatment rendered and patient progress are other aspects of documentation or other purposes of documentation. So when you document the day's treatments, you should describe the date, the time, the individual or individuals who provided the care, which pathology was being treated, what modalities and exercises were used, and what the parameters were. Pre and post interview should also be documented in the medical record. So talking to your patient before and after the treatment would be documented in your medical care as well, in your medical record as well. Also, documentation serves as a legal record. So well-documented records assist in improving that staff exercised reasonable patient care. If a liability case were to come to trial, the medical staff would use the records to refresh their memories when testifying about the case, and also the documents themselves may be admitted as evidence. So we need to make sure that we write high-quality documents, legal or medical records, in order to remember what we did with these patients and be able to testify on our own behalf, but also because the documents may be submitted as evidence in a case. Because of this, then, we need to use standardized terminology in medical shorthand. So what abbreviations, what terms are you going to use? You need to understand the professional standards of practice because they will require complete and accurate medical records, which is another way of saying if you're not keeping good medical records, you're breaking the law. Medical records correlate the care given with that prescribed by the physician. So you can prove that you did what the physician instructed when they were evaluating the patient. That assumes that sometimes physicians are referring patients to athletic trainers. There are different work settings such as high schools, colleges, for-profit clinics, and hospitals that may have additional record-keeping requirements. So a real basic example of that is when I was working at Amelia, they really didn't care at all if I had medical documentation for the athletes as far as the treatment that I was giving in the athletic training room. What they cared about was that I completed the insurance form for the school. It was called an incident report form, so that the school could then file with their insurance company to reimburse the student for any out-of-pocket expenses. So the students in Amelia, if they had to go get medical care and their parents had primary insurance, so their parents had their own health insurance, then the parents would pay the copay and the other expenses related to a incident, like a visit to the emergency room, and then any out-of-pocket expenses, including the copays, including the cost of the crutches or the cost of the MRI, whatever the out-of-pocket was, the school would reimburse them. But in order for them to be reimbursed through the school's insurance company, they had to have this incident report form filled out. So you may establish what you want to be the documentation standards in your athletic training room, but you also have to realize what's going to be relevant in the facility that you work in, so in the school, for example, and what's going to be relevant to the patients and their parents, because they just needed to have that one form filled out that said that there was an accident and it was related to sport participation, and that was it. So, great, it's good that I was keeping excellent records, but the only person that was ever going to read them was me. So that makes for sort of I felt like that was a little bit of a complicated documentation situation when the school only wanted this base level, but I knew that I needed to document something much more thorough. So these are, questions that you may find yourself dealing with as a practicing athletic trainer. You also want to understand how to reimburse for documentation. So we're going to talk a little bit about third-party reimbursement. Insurance companies require the use of goal-based treatment plans for reimbursement. So when you're dealing with working in a clinic where you can actually bill for therapy services, the insurance companies are going to want to know that you set goals for the patient and that the treatment plan that you're doing with your patient is based on those goals. Therapeutic services billed for this purpose will be reimbursed only if they meet the patient's treatment goals. This is another reason that I spent so much time with you guys the other day on goals. If the patient continues to show no improvement, or if the protocol does not appear to match the patient's goals, payment for services can be declined. So when you work in a situation in which you're trying to get reimbursed by an insurance company for athletic training services, you're going to have to be very savvy, very knowledgeable at what will be paid and what will be declined by the insurance company. it ends up being a very big deal. It affects your bottom line. It affects how much money you make, very, very easily and very substantially. All right. So another reason to document then is third-party reimbursement. So the concept of third-party reimbursement is receiving reimbursement for services rendered, and it requires the documentation of the condition being treated and documentation of the treatment services that are being billed. The individuals rendering the treatment must be state licensed in their area of practice, and the treatment provided must meet the patient's treatment goals. The decision to provide reimbursement for a claim is ultimately left to the individual insurance company. So a third-party reimbursement says that the patient sees a doctor, the doctor refers the patient to the athletic trainer provides the treatment, and the athletic trainer seeks payment for that treatment, not from the patient, not from the physician, but seeks payment from an insurance company. We are not allowed in Virginia right now to bill insurance companies for athletic training services, but that is one professional goal that we hope to have that privilege in the future. Okay, so one of the last big concepts we want to talk about then are billing codes. So in this section, we're going to talk about the International Classification of Diseases codes. These are referred to as ICD, and they would be numbers assigned to the patient's pathology. Then we're also going to talk about current procedural terminology codes, or CPT, and that describes the care provided to the patient. So if you're going to be engaged in third-party billing, you're going to have to be really good at applying these billing codes correctly. Improper coding can result in the claim being rejected, facility being audited for safety and other aspects, the loss of provider status with a particular insurance company, and also fines. So billing is a really big problem because it's many, many times done inaccurately, and you have to do it accurately in order to get reimbursed and in order to keep yourself out of trouble. All right, so another reason to document is to enhance your evidence-based practice. So to control costs, third-party payers are requiring documentation and evidence that the treatments being rendered are beneficial to meeting the patient's treatment goals. So it would be proof that the treatments, and by extension the modalities, produce the effects that we believe is termed evidence-based practice. Okay, so in other words, when you're documenting, you need to make sure that the treatments that you're including in there, you can actually prove that they worked. Okay. Last concept, facilities. It is incumbent on the athletic trainer to run a facility that is safe. So we're talking about the physical facility where care is given, and it must be free of potential hazards and be conducive to patient care, including access by disabled patients or clinicians. So of special concern are the hydrotherapy area, the treatment area, paying attention to your plumbing, and also to your electrical systems. All right. So some modalities are going to operate on a 110 volt outlet, which is your standard household outlet, while others may require a 220 volt outlet. The biggest thing that you probably need to pay attention to, though, with your electrical outlets is not so much the 110 or the 220, although if you're doing building design, you would definitely have to pay attention to that. But we also want to pay attention to this concept of ground fault interrupters, or GFIs. They are recommended for all outlets that will serve patients. They're especially important in areas where there may be water. So your hydrotherapy area needs to have electrical outlets that are 3 feet, 4 feet off the floor, and that also have ground fault interrupters in them. Surge protectors may also be required for electrical stimulators. In the treatment area, it should be spacious and well lighted. The treatment table should be approximately 30 inches high, although adjustable tables are recommended and also will meet the Americans with Disability Act. Split leg tables allow for the body part to be elevated during treatment. That's a good idea. If shortwave diathermy treatments are to be used in the facility, all wood tables are required. So we basically have wood and padding tables in the athletic training room, and that would be fine. We just can't have a lot of metal or any metal in the diathermy area. Your hydrotherapy area needs to have on-off switches controlling the whirlpool motors that are located so that a patient who is in the tub can't reach them. So you turn on the whirlpool without the patient in there, then you put the patient in, then you take them out, and then you turn off the whirlpool. And we'll talk about that when we do our thermal modalities. The hydrotherapy area must be in full view of the staff. It must be cleaned and well ventilated, air conditioned, and we'll talk about the cleanliness when we do whirlpool treatments as well. Whirlpool temperature gauges should be calibrated annually, and the floor should be covered with a non-slip surface. Also, it should gently slope toward one or more of the floor drains.